Aha, any about breaky at the mama, Kpandai rerun of elections, Supreme Court, Quash, just or cancel rerun, Babe Koso, Kpandai, just NPP, Matthew Nyandam, just victory, Banafa, and Sembi, Asanso Abba, political highway, so aha, Gospel Politics TV, so unsubscribe, subscribe, hit it on the notification bell, send any updates be ever dropping on so able to me. Akabina. And Sembi Koso on Kpandai round of election. NDC legal team at the Babontin, sir, Quash Supreme Court, Quash elections. No, Omobe review, sir, Quash Supreme Court, Quash, no, Omontiasi and NTC, na NPP for a percent Omofa, Petu Kwai Bisona, HSA Omodi Chinchim Omonsa, and NDC PC, and as NDC candidates. Of Kpandai no ene wakopimo one NDC legal team akopimo ewo Supreme Court abusuya eno ena ya project ede atu ye screen no enchen ede amam no say NDC Kpandai parliamentary candidates filed a judicial review of the Supreme Court judgment which quashed the High Court ruling on elections. Also the NDC Kpandai parliamentary candidates files a judicial review of the Supreme Court judgment which quashed the High Court ruling on the elections. Abusuya nature say NDC amanyoko ne omon legal team no omon back off on a Supreme Court ruling on a Kpandai or Quash rerun of elections. No na abusuya ehun sem bebre NDC mpanyim fo ni bi ababet na sede ensembi ababet to jafa. Amom yanko na yanko nkoti ensema ekoso our political highway. So unsubscribe subscribe na hit on the notification bell send be any update be ya be drop your political highway ni so be an won so wonsa ebe to me aka medamase.
The earlier decision of the High Court ought to be upheld. The fact that there ought to be a rerun, a by-election in the Kpandai constituency, because the ruling by the Supreme Court granting what the current or incumbent MP Matthew Nyandam went to court for, asking the decision of the High Court to be quashed, will not lead to the delivery of justice for the people of Kpandai. In fact, the new basis for which we're having all of these claims being raised by lawyers for this NDC candidate is that, first of all, they are relying on Article 99(1) of the Constitution, and that the fact that the Supreme Court, according to their view, did not take a look at issues from the perspective of Article 99(2) of the 1992 Constitution. The argument being made now is that if you're aggrieved by a determination of the High Court regarding matters specifically relating to the outcome of a parliamentary elections, then you must appeal to the Court of Appeal. So that's a new twist to the matters for which the NDC candidate, through his lawyers, is now asking the Supreme Court to consider a review of the matters that may possibly lead to a situation of a by-election if indeed the Supreme Court departs from this earlier decision they gave, quashing the decision of the Tamale High Court. Quite a controversial matter coming up again, just on the back of a by-election that's just ending in the Ayasu East constituency. So how does the NPP view this? The fact that their numbers in Parliament may further dwindle. That's the concern emerging. Okay, I'll tell you about my guest joining us to do this. First, though, online is the legal spokesperson of the Minority Caucus in Parliament, lawyer John Dako, who's MP also for Swami. And then we have Wanda Victor Kuto, who is a member of the National Executive Committee of the National Democratic Congress and also a board member of the Volta River Authority. I'll get back to him in studio shortly. But first, let me start off with you, Counsel. Is this a surprise to you? Because many were thinking that once you have the Supreme Court make a decision or a determination on this matter, that would have been the end of it. Except to say that they're free to depart from their earlier ruling. So the NDC listen to lawyer John Dako on these emerging matters. First of all, I mean, why the desire to clinch onto more seats as the National Democratic Congress? Is it the case that you're hungry for more parliamentary seats? Because, I mean, you have quite a number of seats in Parliament now.
Thank you very much. Good evening to you, the the council on Zoom, and then to our viewers. Yeah. I mean, clearly, none of the MPs in Parliament will be able to push the agenda of the NDC in Kpandai rather than the NDC PC. So it's natural for persons within the party in Kpandai to want to have a member of Parliament representing them who is an NDC activist. I mean, it's natural. But talking about the legal issues, I agree largely with the MP for Swami, largely, because the matter that was before the Supreme Court, it's not a petition. It's a certiorari application. That was what was before the Supreme Court. It's not the substance, it was the procedure. Because the MPP's argument, the embattled MP at the time, argument was that the High Court lacked jurisdiction because of the late filing.
Yes.
That was the matter before the Supreme Court.
And that you relied on a different gazette.
So that even comes to light on the issue of institutional weakness. That's where I'm even going to. We should be able to, as of right, find out when was the election for Anglo or Keta or Temali gazetted. We should know. We don't have to struggle that this person will say, oh, this result was gazetted on this date. This person will say, it should be something simple.
Yeah.
So this the institutional weakness we have in this country.
But are you sure that was the case of institutional weakness? Because if you read the ruling of the court, they argue that matter has been settled in the Akwitia case.
That's what I'm saying. We've been in this country.
So if it's settled, didn't the NDC lawyers know about this before?
We've been in this country when even presidential result was amended 3 or 4 times. That's what I'm talking about. Presidential election after declaration in 2020 was amended 3 or 4 times. These are the cracks of the matter. Parliamentary election petition is governed by 2 major laws. The Constitution, Article 99, and then Section 18 of the PNDC law, I think 284, regulates it. Section 18 talks about the fact that you must file your petition within 21 days.
Yes.
You understand?
Yeah.
Anything short of that, the High Court will lack jurisdiction. Right. The MPP rightly invoked the supervisory jurisdiction of the Supreme Court, and the certiorari application was granted. If there's contrary evidence to show that the petition was filed within 21 days, then the review application will be tenable, will be justifiable. But if there's no contrary evidence, then there will be no need to go for a review, to be very honest. I mean, when it comes to the law...
So you feel there'll be a challenge there?
But because the issue is the 21 days, that's the issue. Yeah. For the substance, that's why people are in pain. Yeah. People are really in pain, because if we know that we voted and our person won, and just because of publication, gazetting, our vote is not being counted, you see that the NDC PC would have lost the case, not on substance, but on procedural matters. And that is what I'm talking about, institutional. I imagine this had happened, this was large scale. How would the country for that wrong people are representing them in Parliament?
Am I getting the sense that you want to attack the Electoral Commission because of this?
Not attack. I'm talking about institutional weakness.
Yeah, but the institution responsible for elections in this country is the EC.
Yeah, and that is the Ghanaian way. Most of the institutions in this country are not living up to expectation. That is my worry. Because how on earth are we in this country? We cannot easily. If I ask you that where you vote, let's say you vote at Yawasu West Wagon, and I ask you,
when was it gazetted?
You don't know.
Oh, why would I tell you? It was gazetted in December, isn't it?
You see, there should be a system so that after election, you can just go online. Oh,
yes, and check.
Tamale was gazetted on this day.
Yeah.
Cape Coast
was done on this day, yes.
We don't have to struggle. Bantama was gazetted. We don't have to struggle. And that is my worry as a country. And when it comes to the issue of the law, I don't do politics. The facts are clear. The matter before the Supreme Court is not the election petition itself. It was the fact that the High Court lacked jurisdiction.
Now, don't you see a new twist? Just as I was asking Lawyer Darko there, that now they're saying, well, in terms of procedure, the NPP side also got it wrong because they should have gone to the...
No. They went to the Supreme Court to invoke the supervisory jurisdiction of the Supreme Court. If you are going to the Court of Appeal, you are going to appeal the substance, that's the election petition judgment. But this one, they are going to get the judgment quashed by a certiorari, and you can only get that at the appropriate forum, which is the Supreme Court.
The review is not going to work, basically. That's what you're saying.
I'm not on the bench. But unless there's a contrary evidence to show that the gazette was done within 21 days, otherwise, trust me, the review will fail.
Lawyer Danko, let me bring you up on that. We're just coming from a by-election, and then now you find lawyers on behalf of this candidate also doing same. Are you down-spirited in Parliament, knowing that your numbers may further reduce? That is, if the courts get to depart from their earlier ruling now.
No, not at all. Not at all. I mean, look, the application faces a very daunting task of even passing the first stage. That is whether there's an exceptional circumstances that must, give the Supreme Court the right to even review the matter and then go into the matter itself. Because before the review application itself is granted, you need to show that there's an exceptional circumstance. I've read the motion and the affidavit, and I don't see the exceptional circumstance that will even allow the court to assume jurisdiction and then grant the application. And so on this, I am very confident that the 4-1 majority decision will stand. We are not down-spirited at all. The NPP is a very strong party. If we have to challenge this, if it comes to it, we'll face them in court. And we are going to do it. Now that they filed this application, we're going to file our response and we'll do battle with them in the court. But we have no doubt that looking at the law and the facts and their application will prevail. But look, like I said, we will talk about the question of law and give the Supreme Court judges the opportunity or the right to give us the judgment. But I think that my friend Wanda has admitted that when it comes to the law, there's no politics. The law is very clear.
Yeah.
The NPP or the Ndam was right when he invoked the supervisory jurisdiction of the court to challenge the assumption of jurisdiction by the High Court. You don't do that at the Court of Appeal. And I am surprised that lawyers will be doing this to themselves. And we should do better as lawyers, not to take any matter to court because maybe clients want them. We should be able to advise clients. And I believe that if the lawyer had advised the client, we even have taken this course, this is bound to fail. And look, there is no two ways about that. Look, when it comes to review, what the judge, the chief justice is going to add 2 more judges to this. All right? And so it's going to be 7 judges. Okay, 7 judges per 7 judge panel. Now, what kind of argument are they going to make to sway these 4 judges who heard the same argument and dismissed it? Because this same argument, like I said, was canvassed by no less a person than the presiding judge at the time, the Honorable Judge Fuaman. He advanced this in court that the NDP should have come by way of appeal to the Court of Appeal under Article 99(2). This argument was canvassed. It has already been canvassed. And the judges all listened and said, no, this is not a determination of the suit itself. This is challenging the jurisdiction of the court. And that can only be done through this invoking the supervisory jurisdiction of the Supreme Court. And so how is this decision going to change? Even if the two comes and they feel that they want to side with Puaman, Justice Puaman, it's still going to be 4-3. Because I don't see how the 4 judges are going to be swayed by this same argument that was made. It was this same argument that was made during the hearing, and nothing has changed. Okay, so I don't know what is going to bring the difference.
If that's the case, how do you respond to concerns that you won on technicality, but the substance of the matter still remains, and that this is also about justice? Perhaps those who queued to vote were not, and we haven't, as of now, heard from any of the judges regarding the substance of the matter, which has got to do with the election, except for Justice Tanko, I guess.
No, but unfortunately, that is how our court system works. You can win a case through technical knockout or the hearing of the actual matter or the definition of the actual matter, and it's a fair deal. When the lawyers make a mistake, such as they did, you cannot blame anybody. Okay, and this one is not just technical matter. It is in fact a statute issue. The statute is very clear that if you want to challenge election petition, you do that within 21 days after the publication of the Gazette notification. You didn't do that. So how do you even bring a matter before the court? So this is not so much about technical point. It has much to do about the lawyers who were involved in this case, that they should have brought the matter sooner than they did. This is an act passed by Parliament, and it has to be respected. That is what we're talking about. It's not so much about technicality, but it's about the fact that they breached a very important statute. And that's where it is. But we believe that even if this matter had been determined on its merit, we believe that we would have still won the case, because having read the judgment of the High Court, I was completely taken aback how a judge can come to that conclusion. And I was very confident that the Court of Appeal was going to overturn that decision. But we didn't get there because we also realized that the court didn't even have jurisdiction in the first place. So we went to that route, and the Supreme Court, by 4-1 decision, agreed with us. And there's nothing wrong with that. It is perfect, and it's a legal route that we took.
Lawyer Wonder, the point about the way forward now for your candidate, he feels aggrieved. He believes that he actually won the elections, except that he can't get any remedy now because of the timeline. How do we balance the two now? Because it's a big challenge.
So like I said, our candidate is not a victim of the weakness of Ghanaian institutions, specifically the EC. He's a victim because if the judgment of the High Court is anything to go by, that there were irregularities. But the only reason why the case has gone nowhere is because of technicalities, late filing. That's the only reason, not because of the votes. And that is the worry, that it will get to a time, if this situation becomes large scale, then we are going to have some MPs in Parliament, not because the people want them, but because of technicalities. That is my worry. After the review, I don't think it will stand the test of time. To be very honest, it won't go anywhere.
Many have described the decision of the High Court judge as very controversial. The fact that the number of constituencies in doubt, it's just a minute part of a bigger constituency. Were you not surprised about that earlier ruling too?
Oh no, but if you want us to go into the substance, if you say those police stations were minute, they have significant impact on the overall election. So if you call for a rerun, I mean, it's fair. It's balanced, it's fair. He didn't say then this candidate is a winner. He said go and do a rerun for people to choose who they actually want. I mean, so that's on the balance. It's much better than this situation that we have, that a person is being forced, that a person case is thrown away because of late filing, and individuals do not gazette their own results. That's another issue. The candidates do not gazette their own results. It's our institutions who are supposed to do certain works. And if this institution fails, people are being what? Punished for that. That is what is happening. The NDC candidate is being punished for a failure of an institution of state to work. And that is my worry. If this becomes large scale, and I repeat, because in the next 2 years, we are going to an election. So one thing somebody can do is just find a way of being declared winner. Once somebody even goes to court to get a judgment, just because the petition was filed supposedly late, you are fine. Is this how we want to be ruled? That we are in a country that you cannot go, there's no mechanism to check easily the date by which results are declared and gazetted? Is that what we want as a nation? I think we have to sit about.
When it was for you in Akwetia, you were silent as a political party.
No, I have been very consistent. I have said that once the laws is fairly applied, I have no issue about it. That's why I'm here saying that if we file for review, I don't think it will succeed, because nothing significant has changed. There's no evidence to show that the gazette was done within 21 days, pursuant to Section 18 of PNDC Law 284. There's no evidence, contrary evidence. So on the basis of this argument, the review application will not see the light of day. That's my point. If you talk about the case of Akwetia, what were the facts? Is it the case that the petition was filed within a particular period, and the judges would otherwise. Is that the case?
Well, no, my point is about the double standard you're talking about in the Gazette, because at that time everyone had known, or by then everyone knew that, of course, the actual date for the Gazette would have been December 24, isn't it? So the candidate in Kpandai should have been guided by that.
But each elections are gazetted, election results are gazetted differently. They are announced differently. They are declared on different days. We can do a roll call of all the MPs. Their results were announced and declared on different days. Some even went as late as when?
After the post that.
Exactly. Some even a week, 2. Yeah. They have to change the collation center, blah, 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 and all of that. I'm saying that going forward as a country, there should be a mechanism. But one thing that happens in this country, unfortunately, is that once elections are over, we forget all the challenges. In 2020, presidential election was amended about 3 times after declaration. But we are all quiet about it. We don't care. Nobody seems to care because the elections are over, there's a president, and life seems to be okay. But if we are not careful, these things will keep continuing. Did you see what happened at Techman South in 2020? It happened again in 2024. Will it happen again in 2028? So if we don't tackle the fundamental issues, we'll be back to the same issues. That is the point I'm making.
Right. And for you, Lawyer John Darko, how much of a responsibility should the Electoral Commission be taking now, knowing that there are some challenges with the Gazette system, is it?
Well, let me just make this point so that we are all guided.
Okay, abusia winning and smart a course so our political highway so NDC and asanso a strike bill on Kpandai Supreme Court judgment or the buyer abusia omasanso a file for a review. Abusia e better must some of Japan cocotiza and some way at the MI gossip politics TV. So unsubscribe subscribe now hit it on the notification bell so any updates be ever dropping also once able to me akabi.